and I'll get started. Well, as I certainly do just appreciate everybody time and attention today. It is, well, first of all, just really extend a warm thank you to Eduardo Gonzalez with the Self-Represented Litigation Network for helping me steer down this path and take advantage of this opportunity to present some of the, present my ideas and really more importantly, to be able to take the opportunity of these working groups within the SRLN to get the feedback. I mean, I've been at this for a while and, obviously I'm not making the progress that I think I should be making. And so much of what so as this is staged, is really, how do I bring change? I mean, how do we all bring change? I think a lot of us have lamented, the family court for a long time. Probably ever since its creation or its existence. We as this, over the years has become more and more adversarial and more litigation and more really harm to individuals and families. And it's just, we all lament it. And where I am today, it's kind of, I'm at the limits of my understanding, limits of my rationalization and ability to kind of figure this out, how to break into this otherwise closed ecosystem of the family court to bring real change. It has, we're talking about problems that have been long-standing problems for 20 to 30 years that have plagued families, individuals, in our court system as well. And so this goes from family court to legal aid, access to justice, and really the entire system is, there's so much opportunity for improvement, but we're not getting it done. So what this is this by and large is just the same presentation that I gave to the Colorado Supreme Court Standing Committee on Family Issues back at end of January, a little bit more than a month ago. But just a little bit of background on me and a little bit more context about this is that I'm a 9-year high conflict litigant, divorce and custody litigant. I am, I founded Split Smart about 5 years ago, so I'm in that, that journey. But in the choice, we'll start from there. So I was able to present. I've been trying to knock on the door of the Colorado, SCAO for a long time, and finally just at the end of January, finally given the opportunity to present to that one committee. But I've been coming at this from, who knows, obviously not quite the right perspective, as I have a 3-decade career in corporate software sales and solutions. So kind of coming more from a process-oriented world, and that's where some of my career and my experience as a litigant really brought me, by and large, to today. But it is that experience as a litigant, which I think is so important, and is what I've been trying to communicate, in recognizing these problems from the perspective of the litigant and bringing it is kind of the way where I'm trying to approach some of these solutions. So the accent's Alabama. I've been in Colorado since 98. Married my ex-wife in 99, and by 2002 we had our first son. In 2004 we had our second son, and 2009 she filed for divorce. And while how all that process, how we started down that process of divorce deserves great examination. What I'm here, from the court system, that's really not what I'm here to talk about. It's really more about this 9-year high conflict litigation process that nobody wins but the lawyers. And it is from that experience, which again, recognizing the problems, trying to figure out really what the court's purpose is, and bringing in the solutions that get us to today. So in that experience, kind of just before, as part of our last round, we're at the court order of mediation in advance of our last hearing, and that's when this all kind of came together for me. We'd spent 9 years and several $100,000, and really was still deep involved in conflict and litigation and everything else. It was at that mediation where I received the email from my ex-wife of her updated disclosures. And as I opened up that email, I could immediately recognize that her taxes had been altered, and the bank statements were screenshots that had also been altered. And I turned towards the mediator, and she just basically shrugged her shoulders and saying, "Hey, I can't police that," and rightfully so. She couldn't police that. And I saw, got to think about it. Said, my only recourse in that situation is to file another motion, is to go through the time, the expense, the conflict, the waste of life, and everything else, and to file another motion that pretty much end up same place where I was. So at that time, I just decided to take my licks and just go on. But that's when the light bulb came on. That's when I figured out that that the courts have all these laws, statutes, and rules that govern the whole disclosure and discovery process, but zero ability to actually enforce those rules, short of one of the parties filing a motion. And that requirement to file that motion, that paradigm of filing that motion, is just this huge barrier to justice. So if we can't have all those well-intended rules, statutes, and laws were intended to help ensure transparency between the parties and to help them get organized so that they are, they can more efficiently and effectively kind of reach that, the fair and equitable resolution. But if you don't have effective enforcement, or people aren't effectively complying with all those rules, instead of protecting the common good, you're really enabling the bad actors. And that's where so much of the problem is. So that is, so in my light bulb moment for Split Smart, it was from the standpoint of, in a high conflict divorce, there are two truths. Pretty much everybody's lying about money to one degree or another. And that the kids are just unnecessarily put in the middle of the parents' conflict. So those were the two problems that I looked to solve in my entrepreneurial efforts around Split Smart. So, and these have been long-standing problems. Again, and courts have been wrestling with this right and left for, well, they've at least been talking about it. It's been on your radar, and it's been, and the system has given great lip service to it, but we've not really, the system continues from a litigant standpoint, from somebody outside the system, it seems to continue, and probably many of you within the system may believe this as well, but it seems like the system is only involved for the benefit of the lawyers and not for the benefit of the families. So let's see what's going on here. There we go. So, I'll recount a lot of this, and again, I think most of you know this or realize this and can appreciate this. But so these, again, just long-standing problems of 20, 30 years. And that, when you're in a contested divorce, in a litigated divorce, let me back up just a second. In my journey of divorce, entrepreneur, being an advocate for change and lobbyist in certain cases, I've certainly developed a variety of different philosophies and beliefs. The one most important one as it relates here is that the single difference between a good and ugly divorce is simply the presence of a bad actor. That bad actor is one or both man or woman, lawyer or litigant. And when one comes to play, the other one's going to naturally kind of respond in kind, and that's really just going to send everything off the rails. And that's when you get into the contested problem of, of people acting out their own self-interest as opposed to, the interest of resolution or for the common good. And so in that case, in the contested divorce, well over half the cost of the legal expense of the legal journey is certainly can get caught up between the expense of disclosure and discovery. Well over half that expense is related to that, whether it's gamesmanship or people trying to hide or deceive. The system itself, the discovery and disclosure process is broken. The system kind of gives itself a false sense of belief that litigants sign, self-certification of compliance. Well, most of us know that that's really not worth the paper that those signatures are written on. And so in this arena, people the expense and the time and the complexity of this all just spirals out of control. Pro se litigants at best case, sometimes they're just confused and ill-prepared and don't necessarily know what to do, but when you get represented litigants, quite often you get the attorneys that are very litigious, and they are oftentimes creating more conflict than, for the purpose of turning up their bills. So I think that's one of the pieces here that even in the talk of this being, a self-represented litigation network, one of the things that the system doesn't look at as much is, again, protecting individuals, quite oftentimes from their lawyers, from their representatives. So it's a very big problem that a lot of us work in. So in this arena, in this high conflict arena, again, the outcomes are a crapshoot. Between the judges and the lawyers and how it all plays out, it's quite often just a crapshoot for the outcomes. And it's quite often that bad actors win. So the people that are more well-resourced or have the more aggressive lawyer, they're going to be the winner. And it really does turn into family and financial ruin for many, many people, sometimes even worse. And while we've talked and lament about all this to a large degree, part of my frustration is how has the system allowed it to happen or continue to happen? Has the system just, talk about it, but is it just kind of more calloused because they've heard it for so much, and we're not connecting the real tragedies with all this in their outcomes. So as part of being an entrepreneur, I'm certainly trying to, matriculate, part of what I know as an entrepreneur in the business world is you're certainly trying to, empathize with those you're trying to serve. And so and I do recognize that their judicial officers, again, judges and magistrates, all well-intended, good people, they stress about trying to see through the clutter of all the BS that's going back and forth, and really trying to get to make those rulings and issue those orders that are fair and just. So they stress about doing the right thing. I know that, but their litigants are, again, either ill-prepared or just overboard adversarial. And so there is ultimately, just really no governance in the data that the judges are seeing, or even in the process, because of our paradigm of having to file a motion to get the court's involvement. We don't know, we are not, there is no certainty about truth and honesty in compliance with, in our obligations. So the courts, again, recognizing the barrier to justice of having to file a motion to get, resolution is a huge, huge barrier to justice that I don't think that we look at well enough in managing high conflict cases. our dockets are mostly overloaded, or caseloads or courts are overburdened with the caseloads, and quite often it's like taxing on the different budgets. But it all boils down to one single core problem. All the rules, statutes, and laws without an effective way to enforce compliance and ensure transparency between the parties. It is as simple as that. It comes down to just being able to have the rules to ensure, let me try to say that again, to ensure compliance with the rules that we've set out to protect the common good. So it is, again, part of that, again, as coming from more of the business world and the marketing world, it's, most all of us as entrepreneurs, we focus in on who do we serve and why do we do it and what is it that we're doing. And I think this, as a long-term litigant who spent big dollars, I think it's justified to ask the courts or the system, who are you serving? We inherently, altruistically, we know that you're there to serve the couple. We know that you're there to serve the couple, to help them reach fair and equitable resolutions. That's your purpose. But by not being able to solve these problems, but again, I think it's a fair question is, are you serving the lawyers that really help steer where a lot of this system goes? Or are you serving the bureaucracy? Honestly, I think it's just it's a combination of both. But to reach those fair and equitable resolutions, we've got to protect the common good and ensure the best interests of our children, when they're involved. And we do believe that the courts are very much want more and more, many cases to be resolved without their involvement. They're happy. Courts are happy when they're not involved. I think that's core of what a system wants. But if somebody is going to come to court, if somebody is going to try to litigate, they need to be compliant with their disclosure and discovery obligations. And those obligations are to one another, not necessarily to the rules and statutes and laws, but those obligations of ensuring mutual satisfaction of completeness and transparency. And if you're going to get to court, then we need to have your issues organized for not only judicial efficiency, which is again a big part of the buzzword here, but for your own sake. So you're cutting through this process that much more. So again, what has prevented the system to getting to the solution? Well, honestly, I think the system has lost focus on who it serves and its purpose. It's so much more it serves the bureaucracy with the bureaucratic and legal blinders. Maybe even say that further, the bureaucratic and legal shackles of keeping the focus on the bureaucracy. So in all that, I think the system has just grown immune to problem solving. It has grown immune to innovation. Well, and maybe I think it always was immune to innovation. But we talk about these problems ad nauseum, but we have not solved them. And the whole addiction to forms. Again, who are those forms for? Is it benefiting the couples that are getting divorced, that need to get fair and equitable resolution? Or is it just for the bureaucracy to say that they're doing what they're supposed to be doing? The other big problem, I think, has been, at least as it is kind of more here in Colorado, is that there just has the closed ecosystem has not allowed for entrepreneurs, and it has not had any litigant representation at the table, besides a survey here or there to kind of say, get their temperature. but no litigants have been involved in trying to reach, trying to reach solution. So the concept, the solution that I was advocating with the Colorado Standing Committee on Family Issues was the concept of passive compliance enforcement. Or said in another way, another alternative approach to that is kind of litigation support. But in this paradigm, in this concept, it solves the discovery and disclosure problem big time, easily. And it provides both litigants with recourse to the documents and to the data being exchanged without requiring motions or the expense and or the risk that comes with that. It gets people to the transparency, not only transparency, well, transparency across the board, in positions, in data, in documents. And quite often, again, in transparency, when litigants are represented, quite often the attorneys see transparency and transparency as a bad word. This is my polite way of saying it, because transparency leads to resolution more quickly. But if we get more passive compliance enforcement, we get transparency in positions, not just financially, but with the family as well, but data and documents. So we have more improved resolution without court involvement, and the litigants are organized for judicial efficiency if they get that far. So what is it? So SplitSmart has developed a solution. I've got pretty much 80% there, and I just kind of need this engagement with the judicial system, with our system, to kind of cross the finish line and get it to where this can live up to its potential of truly being disruptive to this arena that we're in. So so what it is a dual purpose solution that that treats every individual disclosure and discovery item as an individual inventory item. And by doing that, we enable 3 core functionalities. First is just a discovery dashboard, just an inventory count of where documents are in the process. I mean, and again, keeping the eye on the fact that our discovery obligations or disclosure obligations are to one another. I can see your dashboard and you can see my dashboard as to how many documents that we still owe, how many that have been shared and accepted, how many documents are in dispute, or how many are still, and how many that are still outstanding. I mean, not all documents. I mean, when people are more reasonable and rational in this process, they want less documents. It's just those bad actors and those that are really litigious. They kind of go overboard with wanting everything under the sun. That's the first piece. The second piece is an opposing party audit function, just being able to give the parties the ability to say yes or no to a document. Yes, this looks good. This is a bank statement. And I can argue the veracity of it, the authenticity of it later, but yes, this is a bank statement. So I give it a thumbs up, and it's stamped and put into the appropriate folder. Or I give it thumbs down, because it's illegible or it's irrelevant, or it's a 500-page PDF that again is completely irrelevant. So I give that a thumbs down and send that back with comment as to what the problem was, what my objection was, or why I'm disputing it. So it's just that immediate recourse without expense, time, or legal risk to just go down that path. The third component here is just these audit trails. The audit trails, just again, I know when a document was requested, I know what and when it was provided with, how it was responded to. And then each iteration of a document, if it has to go through multiple iterations. So at the end of the day, I mean, we kind of resolve oftentimes the gamesmanship that goes on in discovery and disclosures. We resolve a lot of the confusion that litigants, self-represented, as well as that self-represented litigants often have, by providing, and at the end of the day, we provide this dual purpose solution that provides the courts as well as neutral, mediators and, the third party, and certainly in the collaborative space, but a passive compliance enforcement, ensuring that people are meeting their obligations to one another. And the flip side of that is instilling individual accountability to the litigants and to the lawyers. And it's a dual purpose system that, to me, solves the entire problem, or the fundamental foundational problems with a litigated divorce. So again, the other way of looking at this is, again, litigation support. Again, streamlining the intake, not around sworn financial statements in court forms, but in layman's terms, making those intakes incomes, assets, debts, and expenses, and then creating these folders dynamically for the supporting documents for each one of those as needed, but as each of the parties want. Then it's the whole disclosure and discovery management of it. Again, the combination of dashboards and opposing party audit and audit trails that, again, solves so much of that problem. And the outputs on the data perspective is a marital worksheet. Again, just like, whether you will call it a joint trial management certificate type of thing, or just the marital worksheet, like many of you already kind of deal with in Excel today. Again, the whole design about it is to get to whether you're going to negotiate, mediate, or litigate, you're going to be organized, transparent, and clear about what your position is, as well as the other person's position is on each individual income, asset, and liability that you have outstanding. That transparency and dynamic information, again, helps alleviate the vast amount of gamesmanship. Then just kind of listing out the incomes and expenses side by side for the parties, both from a monthly and annual basis. Again, one of the problems with kind of the sworn financial statements is we're trying to take that snapshot in time of a moment in the past instead of planning for in the future. And that's where these are the core outputs that people need to get to their resolution, however they're going to get there with litigation or negotiation. And from a document standpoint, the litigants have created a common repository that's just organized and compliant with meeting their obligations to one another. And if you're going to litigate, again, creating the exhibit books from that get-go, or from that perspective. So one last point on transparency, not only from a financial perspective of property division or whatever support that may be coming into play, but again, transparency is just as important about parenting plans and schedules and trying to figure out what works best for parents from that perspective. We're not talking so much about kids today, but transparency is just as important there as well. So the litigation support, the litigant benefits. I mean, this is just a small sampling what the benefits are, but it slashes the cost, conflict, and litigation. It's in layman's language. So even the self-represented are well prepared and ready for court if it gets that far. But the transparency just increases ADR success early on, and it really avoids more getting there. Then at the end of the day, it helps, the process helps protect the disadvantaged. And again, so when we talk about that bad actor, now we're able to help protect individuals, sometimes not only from the other, but sometimes from themselves, to get to the promised land of reaching good resolution. But they both win and leave with the process with their bank accounts intact. The court benefits are a less adversarial courtroom. That's what we've all talked about. that, again, relieving some of that judicial stress. It's effective Colorado rules of civil procedure rule enforcement. Sure, we may want to enhance some of those rules later on once we kind of better understand what this paradigm looks like and how it operates. But we don't know until we get that engagement and go down that path. But litigants are prepared, compliant, and transparent. I have increases governance. It gives governance into the system that really is devoid of it now, and really helps facilitate judicial efficiency. Bottom line, reduces dockets and caseloads. So again, this is my presentation to Colorado, and I then advocated about what are the next steps. To me, it is take ownership. If not you being the system, you being the courts, you being the bureaucracy behind the courts, you being the access to justice, the legal aid, if not you, who's going to solve this? Focus on who you serve as the couple and helping them reach to that fair and equitable outcome. That's your purpose. Imagine what imagine what the potential and possibilities. What if this could reduce your dockets by half in the next 3 years? Be bold, disrupt. I realize disruption is probably a foreign word in this arena, but realize that disruption, Uber didn't disrupt taxis from within. Apple and iPhone didn't disrupt cell phones from being a part of the phone companies. Airbnb didn't disrupt hotels by being part of the hotel system. Disruption comes from outside of it. Transform. You have this opportunity to transform this. We have this opportunity to make generational change. So my next steps, hopefully, is more questions, engage, and pilot and solve this problem that have been longstanding. So I appreciate you letting me chat for a long time and your attention, and really putting this out there. And all honesty is to try to get a better understanding of what am I getting wrong? How do I improve this? And how do I move this along? It's just entirely, it's a challenge. So let me open it up and see if I can get any answers or questions from others, and comments, feedback, thoughts, insights, engagements. Thank you for letting me speak to you, but please give me some ideas. Don't all of you chat at once.
Can you go back to slide number 9, please, Carl? Is the intention to have the court adopt this as a system that the parties would be required to use?
Again, that's been part of the challenge. Again, so because courts so quickly, or at least in my efforts to try to engage Colorado, is that they start all these conversations about we can't order systems, we can't require people to do this, that, or the other. And so people just kind of jump to that. Okay, what do you want here? In my mind, so the courts every day in family court are ordering systems, the co-parenting systems, our family wizard and the like. And they're doing so without objection because at least one, if not both of those parties want that help or want that protection, want to simplify things. And so I guess in my perfect world, so the courts would require, not necessarily my system, certainly I would like for them to read my system, but but the system to do something similar. Again, trying to make this more of a generic topic of litigation support. because courts struggle every day with, again, the self-represented coming in unorganized, unprepared. And so, yeah, but part of that is just being able to let's test out this theory. Let's pilot it and see what works and what needs, how we can improve it. How can we, again, deliver a system that works well for the courts as well as for the litigants, while protecting all the things we need to protect.
So I understand your point about a bad actor not being cooperative, providing you missing information, not providing information, providing wrong information that require additional motion to get accurate information. It's one of the problems that you encounter as a self-represented litigant, is that you weren't aware that that exists, that problem might arise, and therefore the initial information request was not comprehensive enough, and that the system would provide a more comprehensive initial demand of information.
No, again, I think the root cause of the problems today is not necessarily the difference between self-represented or a represented litigant. It is that to have any recourse, you got to file a motion. And that system, again, is a system that helps a bad actor attorney fleece his clients. I mean, I really hate putting it in that type of term, because I know that lawyers, there's just a subset of those lawyers that really are trying to drive bills up. But we all know the adage, nobody wins in divorce but the lawyers. But I really think that is because the judicial system is by and large, hand in glove with the legal arena, obviously. It is, again, getting to the core of the problem and protecting all of us from ourselves, from our, the attorneys that may represent us and represent us and protect us from the other litigant as well. There's still, I guess, some philosophical approaches to that, but it is about the problem.
If the other party is recording the system and they are that actor, wouldn't you still have to have a motion to force them to use the system?
Well, so I guess that's the great thing about it, is when you have the audit trails and the opposing party audit, and so you can see all the back and forth instead of going back to all the email change and trying to piece those together. So I think it does eliminate the vast amount of discovery related motions. The motions compel or contempt, because the truth of the process is there in black and white. Right? I mean, because we know what was asked for, what was provided. And so instead of the song and dance of trying to, again, mislead the other or mislead the court, I think again, this solution slashes the discovery related motions 80%.
Oh, so did you encounter a situation where the other party did not provide something, but they served to the court that they did?
Oh, I mean, absolutely. I mean, I asked you something for 4 times, and you tell me you provided it 5 times, and none of those being legitimate.
Got it. Okay, so what's missing is the audit trail for the information. So metadata, let the data. Okay.
Yeah, I mean, somewhat metadata, but yeah, I mean, more just, kind of a core audit trail. I mean, meta's a big word these days.
Would the system make sense if you were to package it as an ODR system for the courts?
It is kind of an extension of the ODR systems. It is just kind of a different flavor of ODR systems, because I mean, whether you're amicable or hostile, you still got to go through all the same process, right? You still have to get organized so you can get to, so you can negotiate and see who gets what, and get to your resolution. So it is by forcing people through the process. If you're going to file for divorce and file as contested. If you're coming down the court, if you're going to be a contested case on the court's docket, yeah, I think the courts should be requiring litigants to use a system like this to solve everybody's problems.
And that's kind of my point, right? You know, part of your challenge is to get the court to adopt something new, and the more new it is, the more resistant they're going to be because they don't understand it. If you present this as a divorce-specific ODR system, you know, this generic ODR system that just facilitates communications and allow a third-party mediator to kind of view into the communication, but a divorce-specific ODR would have like worksheets, forms, to-do lists that are specific to divorce cases that are not applicable to other cases. It basically is a more effective ODR system. I mean, I have a hard time imagining a court would reject a better ODR system.
Yeah, it is. You know, it is. It's just being able to have the conversation with them, Ben. You know, just being able to be, you know, again, the environment is so closed. Everything starts off as we can't. And what I've come to, I mean, in my very, you know, again, trying to be respectful manner, but it's we can't take the time to explore or understand or question. We can't, you know, we can't. All it is we can't. It's the bureaucratic shackles that said, you know, we can't explore because this isn't a finished solution. But I've got the promise of, you know, all these great things, but the bureaucracy says, no, we can't engage with you. We can't even look under the cover to see what the heck it is you're talking about. Yeah, you know, so I'm again kind of that.
At the beginning of this presentation, I thought you mentioned that this is a presentation that you presented to the court already, or did I misheard that?
Yeah, I mean, it is a presentation that I presented to the Colorado Standing Committee on Family Issues, which is a committee of, I don't know, 12, 15 lawyers and litigants, I'm sorry, lawyers and judges and don't mean to be offensive, but bureaucrats. And no litigants in that. So again, trying to position a different paradigm or a different concept that deserves understanding or exploration or debate. Can't even get to that. I gave a 130-minute presentation, pretty much this, what you just saw. And they followed up with me and said, yeah, well, we're going to do more. We're going to do more judicial training. To me, just another initiative that's not going to yield meaningful results for the court or litigants, but they're full of initiatives.
Right. So that's why my comment is around the positioning of the product, right? So you know, you did have an opportunity to present to them. It did not stick. Perhaps you change the positioning of the product to something that they're more used to, like ODR system. That might be a different way to get the message to stick. It's really about finding the right message that sticks.
True. True. Lawrence, you sent me a couple of emails. What are you thinking?
I just wanted to introduce you, introduce myself to you because I have been trying to do privately, what you're trying to do as well. And I noticed that you're presenting to courts, but have you, you know, I think the private industry is a way to go and is a solution. If you hit a wall with the courts, you know, you're starting in Colorado. Of course, it's a countrywide problem, and there is similar problems from state to state. And you're talking to a group that's trying to help self-represented litigants. My personal solution is to train self-represented litigants to better be able to communicate with limited scope attorneys to do what they can't do themselves. and to do that primarily through video or online courses where the cost to the litigant then becomes 10 or 20 cents on the dollar to what it would otherwise be, because you are facing a system that's basically $1 trillion industry if you look at the numbers, or 50 billion per year. So everything that you're talking about, all the problems, the problems in discovery, it's a problem that the players, the bureaucrats, the lawyers, and the judges, that all of them, first of all, that only really involves the top 10 or 20% of the litigants who have money, who have a lot of money. But by the end of the divorce, they don't have any more money. So everything becomes moot because everything went to the lawyers and there's nothing to divide anymore.
Right.
So that system is self-perpetuating because, as you just noticed, it enriches the lawyers. So the problem remaining is the one with the people not having any money anymore, the self-represented litigants. This is where I try to approach the problem. And I think that you're not alone. There are companies like Legal Shield, LegalZoom, and other private companies that are trying to do things cheaper that the powers do expensively so that people can still save some college money, some assets, some homes for their families and children. But I don't know that, the court wants the judges, the masters, they want them to have power. They like discretion. They like them being able to wield power, but it's up to us or private industry to empower the people, or the people with less money rather than more. So I would encourage you as an entrepreneur, someone who knows software, someone who can create systems, to approach it. Keep that in mind, keep that approach in mind, where you aim resources at the person who's only making 50 grand a year, when they face with a lawyer who says, yeah, my retainer is going to be 20 grand, and they have, I can give you $500. Can you put that as a down payment? So point is, I just think there's opportunity, but it's not with the system. I think it's in the private industry.
Yeah, and so I mean, the entrepreneurial journey, I've been at this for about 5 years, and so it being in software development, then you certainly know those. You hook up with the wrong person, developer, and they take you down a wrong path and spend lots of money, and you get to a certain point. The system where it is today has been developed really for the couple themselves, and so while it was inspired for the high conflict, it really, as it sits today, is very capable tool for that more amicable couple. But there's only access for the couple, and so we don't solve the litigating problem until build in the function for the lawyers, build in the function for the courts to make this the promises of this approach come to fruition. And so it's in that. So when you when you have both couples, I mean, part of the adoption out there is when both really wants a good solution. But when you got one that's trying to play games, they don't necessarily want solution. They think, again, and that's where I'm trying to get to the worst of the worst and have the courts take an interest to solve a problem that they have, to solve a problem that their litigants have, and live up to their promise and purpose of who they serve, and engage to solve this issue that they are going to spend probably tens of millions of dollars on this year trying to solve, when I've got something ready to stare them in the face. But
Well, I don't want to take up the group's time, who may have other feedback for you, but Carl, perhaps we can follow up offline.
Absolutely. Great. I certainly appreciate that. Marcia, how about you? Marcia Mansfield, you still on? She may have left. Anybody else get some valuable feedback for me? All right. Well, with that, I'll give everybody a few minutes back in their day. Lawrence, I certainly will be following back up with you, and I'll be getting out the recording of this to all those who attended. And let's see, we got one more message that came in. Eduardo, thank you for making this happen for me, buddy. Y'all be well. Thanks for your time.
Thanks, everyone.
Thank you, Carl.